All right, hello everybody. I'm happy to welcome you to this panel session of the Society of International Economic Law's Global Conference for 2021. And this panel, panel 10, is called Trade Linkages 2.0, Human Rights, Labour, Private Standards. My name is Tania Voon, and I'm a professor at Melbourne Law School in Australia. I'd like to begin by acknowledging the traditional owners of the land where I'm standing, the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present. I want to point out, thank you to our participants, that this session is being recorded so that it can be made available in this platform for the next couple of weeks and possibly later on the YouTube channel of SIEL. The session is supposed to wrap up in 75 minutes. And so we have a total of 15 minutes per speaker, including questions, and there will be additional time for questions at the end. So please feel free to use the public chat function for your questions. And I'll relay those to the speakers. And I'm going to, we'll all be on stage. We're just missing one speaker who's arriving but is having technical difficulties. But we are planning to all stay on stage during the presentations, but I will just introduce the speakers one by one as we go through the different presentations. So first of all, I'd like to invite Chuc Gamboa to provide the first presentation. Anna is a PhD candidate at the Queen's University Faculty of Law, and she has worked in Mexico as a lawyer and as a university professor teaching foreign investment and administrative law. She holds a master's degree in international law from the Graduate School of Government and Public Policy at the Monterrey Institute of Technology and Higher Education. And she holds a second master's degree in constitutional law from the Autonomous University of Yucatan. And recently, Anna completed an internship at the World Trade Organization. She speaks Spanish, English, and French. And her paper today is called The Causes and Consequences of the Historical Estrangement Between International Trade and Human Rights. Thank you, Anna.
All right. Thank you, Professor Tania, for the presentation. So, without further ado, I'm just going to start. It was not until the isolation of the second wave of COVID-19 that I knew it was time to teach myself how to ride a bike. As I am 30 years old, I was too afraid of falling. Yet I went to the park with all the knowledge acquired from watching many YouTube videos on how to ride a bike, and I spent hours there literally pushing myself to do it. It was almost a magical moment when I got it. It was all about balancing. For some, the process of learning how to ride a bike can be a challenging one, even a scary or a dangerous one, but I can assure you that it's worth to try it. Now, you might be wondering, what am I sharing you my biking learning experience with you this morning? Well, as a bike has two wheels joined by a strong structure and a single purpose of transportation, after the Second World War, international trade and human rights were two parts of a single international structure for the securing of world peace. On the one hand, the UN members were called to create an international trade organization for the purpose of achieving high standard of living, full employment, and condition of economic and social progress and development. For that purpose, governments established certain objectives. Among them, it was, of course, the reduction of tariffs and trade barriers. But also, the trade charter included an unemployment chapter, which included a chapter or an article on labor standards, since at that time governments agreed upon the fact that unfair labor standards could hinder the greater purpose of the envisioned organization. In parallel with the creation of the ITO, the UN members began with the drafting of an international Bill of Rights. The post-war human rights project meant to be a single binding document of international agreed upon human rights, including civil, political, economic, social, and cultural rights. However, the drafting process resulted more challenging than expected, and the International Bill of Rights became a threefold project that will comprise a non-binding declaration, a binding covenant, and measures for implementation. Hence, in 1948, the UN members signed the Havana Charter for the ITO and the Universal Declaration of Human Rights. Together, trade and human rights will contribute to the creation of conditions of stability and well-being needed for long-lasting world peace. So, my research began with the observation that the post-war trade and human rights project shared three commonalities. First, a common legal framework, particularly Article 55 of the UN Charter, parallel institutional origins, and an overlapping purpose. Moreover, these two post-war projects had a common point of connection, which was the attainment of fair labor standards. However, my research is about the international estrangement between international trade and human rights. So, how did this estrangement take place? First, the ITO was never created, but the General Agreement on Trade and Tariff took its place with a narrower purpose which did not include economic and social progress and development, nor it had the Article of Fair Labor Standards. Also, the International Bill of Rights became an incomplete project as it took several decades for the covenants to enter into force. Moreover, the human rights regime was split into two separate covenants. On one hand, we have the civil and political rights separated for economic, social, and cultural rights. Accordingly, international trade and human rights became two isolated branches of international law. That is to say, rather than being two wheels of a single bicycle moving toward a single purpose, they became unsteady unicycles, struggling to find balance and to some extent hindering the attainment of overlapping purposes. Then, beginning in the 90s, the trade and human rights debate was catapulted in a spotlight with the anti-globalization movement. Arguments against international trade rose. For example, human rights activists and NGOs suggested that the law of the WTO undermined the ability of governments to protect labor rights and to protect the environment. However, I argue that trade and human rights debate is not necessarily the consequence of a conflicted relationship between laws, but the result or the consequence of a historical institutional estrangement between the two regimes that were envisioned as a single plan and as a two piece of a single project. The historical assessment of the evolution of these two regimes reveals an intertwined path between international trade and human rights, a path of full and missed opportunities for a better integration between regimes. Moreover, the assessments reveal the consequences of the institutional estrangement between human rights and trade. For example, in the 50s and 60s, one can see the emergence of a pragmatic market liberalization in which nations prioritize economic institution building over human rights. For example, the covenants were not completed until 1966, and it took over a decade for them to come into force. Also in the 70s, we can see another example. As economic and social development were not part of the GATT purpose, developing countries sought to transform the trading system. So in 1974, the developing countries achieved a resolution of the United Nations for the establishment of a new international economic order. Also, many of these countries use particularly human rights in social, economic, and social rights in order to establish or in order to accomplish economic purposes. Finally, in the 80s and 90s, with a neoliberal market-driven development model, trade liberalization increased while the protection of social and economic rights decreased. So in 1995, the World Trade Organization was born as a promise for further cooperation among states to free the channels of world trade in the attainment of better standard of living. Yet, the institutional estrangement between human rights and trade remain. I want to conclude my participation with the following thought. I believe that from the ongoing pandemic, we can learn several things. And it's not just about learning how to ride a bike, of course. We can learn that economic questions cannot be solved by governments independent of social and moral questions. If economists, policymakers, and international lawyers are to successfully rebuild the economy after the pandemic in a way that it becomes more oriented to social justice and world peace, then they will need to address the institutional development or the institutional estrangement between international trade and human rights. So I will stop my presentation here, and I'm looking forward for the questions.
Thank you very much, Anna. So I might start with a question. And my question is whether you could say more about something that's mentioned in your paper, which is how a greater recognition of human rights might be reflected in institutional reform of the WTO.
Yes, thank you for that question, Professor Tania. As I mentioned earlier, when the WTO was created in 1995, there was a genuinely belief that by having greater expansion of world trade, then social and economic goals will be achieved through the economic development produced by free trade. Now, in that point of view, they were left of the WTO law some important issues. And I would like to pay further attention on how the process and production methods are an important key to see or to regulate how these products enter into the trade flow. So I believe, and this is my own opinion, that an important part of the production should be reviewed, and the law of WTO may be looking to that. I think it's already doing toward that path in order to incorporate some other areas, perhaps in human rights law, into the WTO.
Thank you, Anna. I might just turn now to Dr. June Namgoong, to ask you a question.
Let me turn on my mic. Thank you very much for your presentation, and I really enjoyed hearing your presentation and reading your paper as well. And actually, I am also the person who has been very interested in this particular topic, linkage between trade and something, trade and that series. And then in my case, it was trade and labor. So because of my background and research interest, I deeply understand many of your concerns as presented in your paper and your presentation. Although I'm a big fan of Professor Oldenick's works in general. You quoted in your paper. It is difficult for me to agree with him on his remarks. History never quite repeats itself. Well, to me, history always repeats itself, just in a slightly different form. And then, while reading your paper, I feel like the linkage issues we are confronted with at the present day have always been there in the past, and I believe, well, I might not like it, but it will always be there in the future as well. So unless we have experienced the global scale and historical events like a world war or global economic crisis we saw like in 2008 or 2009. So I believe if you'd like to invite to the negotiating table developing countries or other countries that may not fully accept the idea of universal human rights to be guaranteed anywhere and everywhere, particularly in a strong link with the terms of global trade or investment, in my realistic view, there must be some incentives, perhaps some economic ones, for them to gain in return. For example, I believe preferential trade agreements, or we call also FTA, which allow their developing country parties more and better access to the market of their developed country parties, may be an answer to that question. I think it is worth noting that human and labor rights and environmental protection mechanisms have been inserted to many PTAs or FTAs, but no such attempts have been successful in WTO forum. So my question, it was long, sorry. Would you please show me or give me some of your strategic ideas to make it happen in this world about this? So.
Yes, thank you, Professor Jun. I also had the opportunity to read your paper, and I really enjoy it. I'm looking forward for your presentation. Wow. And I think that you are right. As we have learned, for sure, there is another phrase that says that people who doesn't learn from history are doomed to repeat it itself. To some extent, history may try to repeat itself, yet the circumstances are different in each way. And I think we have been learning. To some extent, it's not the same war that happened after the Second World War as the war that we are living today. Certainly, we have our struggles, and to some extent, international trade and human rights areas are under the spotlight and are struggling to move forward, and that's why we are talking now about WTO reform, and also in another forum we should be talking about how human rights can also be used in order to promote a freer and a fairer trade. I believe this should be a two-way conversation, and it's not only about what trade can do for human rights, but also what human rights can do in order to have a fairer and a freer trade. So now moving into your specific question about how there may be economic incentive in order to achieve this better integration between regions, I completely agree with you. I believe that this is a personal and opinion, that free trade agreements or preferential trade agreements are a tool, are building blocks for a future agreement within a multilateral arena or the WTO. I believe in history this happened before the WTO was created. There were Tokyo agreements, and somehow it started moving, realizing the way that like-minded countries start to think and start to be built. I think this is important, but I think what we have been missing is that it's not only about the trade agreement. One is that it's signed and how the adjudication process can have economic sanctions or a preference agreement, but also it's important to know that to realize the whole process of a free trade agreement or the trade negotiations, and this is key. What happened during the negotiations is very important in order to have or incentivize developing countries to have higher standards of living. For example, I believe in the case of Mexico, it started to making some reforms and some labor adequation of the labor law or human rights area. In the 2011, we have a constitutional reform of of human rights in order to have access to other markets. So the process before the trade agreement is signed is also important. So it's a huge word that we should take into account.
Thank you.
Thank you, Anna. I can see we need to stop, unfortunately, but I can see there's some questions for you in the chat, the public chat, that you may want to look at. And just a reminder also to the participants that there's also a Q&A function where you can request the stage. So we might use that at the end if we have time. So if you wanted to ask your question yourself, you can also request the stage there. So thanks to Anna. Now, unfortunately, our next speaker isn't here yet, but we're hoping she'll still be able to join us once her technical issues are resolved. So we're going to move on then to our next speaker, who is Dr. Natasha Georgiou, who is a research fellow at the Wits School of Global Governance in Johannesburg, South Africa, and a former doctoral research fellow at the Oxford Institute of Energy Studies in Oxford. And she was recently awarded her PhD from the University of Reading School of Law, where she is a sessional lecturer in the LLM program. Whilst undertaking her PhD, Natasha was a visiting scholar at the Law Department of the European University Institute in Florence and a research fellow consultant at the Energy Charter in Brussels. And her paper is on discourse in the narrative of the EU's value-based agenda in international trade and its external energy relations, the external dimension of the EU internal market, and its effect on the Russian gas sector. Thank you, Natasha.
Right, so my paper looks at the dimension of the internal market rules, and in order to undertake my research, I assessed the internal dimension of the EU's energy policy, which promoting a fully liberalised gas market, and then implications for Gazprom and the Russian gas sector further analysed. Now, for those who don't know, Russia's largest vertically integrated state-owned energy incumbents. Is when I refer to internal market Gazprom, there is an inevitable for the Russian gas sector, because Gazprom is the largest energy company and it's majority state-owned. So you can see there's a correlation there. So in order to my research assess the internal dimension or the external dimension of the internal market, I had to explore the EU's energy policy. This is significant because there is no competence.
She's frozen, right?
We'll just wait a moment. Hopefully Natasha will be back.
It's in the Treaty of the Functioning of the European Union, and to a large degree there is no express external objectives, and they have largely been externalized. And this is largely because the EU externalized legal competence framework, and that is in trade and security and foreign policy, which is a clear crossover with that sectoral competence. So, and the reason why that is significant, because whilst there is no express external competence in the energy sector and there's no express external energy security competence, the EU derives its competence of an inadvertent, which is its ability to conclude agreements in energy. So, and with respect to that competence, or the of its competence or its ability to conclude agreements, the EU's action on the international scene has to be guided by a promotion of EU values and objectives in external action, namely democracy, rule of law, human rights. However, there is no express mention
or in those objectives there's no mention of energy security. So here we can see there is an implied external power, and this is a residual competence where the EU,
where there is a necessity to do so, where it's in the interest of
pursuing one of its objectives in the treaties, or where it's been explicitly mentioned in the treaty. Energy policy and security of supply is mentioned
as competence, and it's
able to with respect
why I've looked at EU competence and the constitutional framework, how it is fragmented, and you can see why the EU
its competence from how it pursues its external energy agenda, and also it does sort of shed light on why there is arguably an external dimension to the internal market rules. So look at the key aspects of market rules and energy regulation, and specifically the third energy package, which is the package
to create
an integrated European market, and it consists of market liberalization measures, and these include ownership unbundling and the
tool that requires vertically integrated energy incumbents to forego their activities, and this is to avoid conflict of interest and any anti-competitive conduct, which could
now the EU.
However, there's a third country clause has been famously dubbed the Gazprom clause because it specifies certification requirements, and of the certification requirements, it explicitly
mentions that the certification can be refused or revoked where the non-EU operator has not complied with energy with ownership. By virtue of that language, or by virtue of the third country clause, all non-EU operators have to abide by the same, and therefore it inadvertently extends those unbundling regime to the
and obviously affects
quite active within the European non-EU.
Here we can see the external dimension to the internal market.
Third country clause applies to non-EU operators operating within the EU.
It's famously dubbed the Gazprom clause because it was intended to curb Gazprom acquiring strategically important energy assets, which would give it a EU entity. So we can see how these conditions and the certification requirements aims to ensure the fundamental
union interests, such as enhancement of competition in its energy market, is upheld and has
intended security of supply. Of the external dimension of the internal market would be competition law, where energy undertakings are reluctant to abide by unbundling rules. The Commission obliges them to do so by virtue of Article 102 of European Union. These developments have also affected Gazprom, and the full extent of the competition law on Gazprom is illustrated by the investigation into Eastern Europe. As Gazprom was basically abused. So an important point competition rules apply even if the conduct is outside the EU. And the significance here is that it shows the extent and the full of competition law and its impact on entities operating both within and out the EU,
where
the market and the internal energy market. So, in conclusion, whilst the EU's unbundling regulation is limited to its own territory and it doesn't specifically address Gazprom, the fact that European energy market and the fact that it is quite active within the EU energy market
in the
union's efforts with the third energy package and its unbundling rules and the third country clause which applies to Gazprom, if we concede that union's efforts with these rules was purely to ensure model with to other EU entities, we can see how the Union has strategically endeavored its internal to push its normative agenda, i.e. liberalization measures, in order to achieve strategic ends, which is so in the absence of a legally binding framework regulating trade, energy trade between the EU and Russia, we can see how they are relying on internal market regulations and how that has obtained an external dimension given its application to gas inevitable implications for the Russian gas sector. So ultimately, is that given the developments in EU energy policy, we can see that the EU is undertaking an active role in EU energy security. There's a security dimension to its internal market rules, and this is clearly an extra its implications for Russia by virtue of its application to Gazprom. Thank you.
Thank you very much, Natasha. So I had a question about your paper. You referred to the EU strategic agenda regarding energy security in connection with Russia as distinct from its usual value-based agenda in relation with other relations with other countries. And I was just wondering if you could explain further the nature of the usual value-based agenda and how it differs from the strategic agenda you have identified.
Thanks, Tania. That's a very good question. I guess in order to draw a distinction, I mean, it's with our EU energy policy can essentially be scrutinized from two different yet interrelated angles, and that is the functioning of the internal market and the forming of the union's external policy. Now, there's a clear crossover between the union's internal market and its external relations, and this is evident in its efforts to promote its liberalization model in its external trade relations. So the union has incentivized its market-based approach by offering a stake in the European market, and it exports its norms through its acquis, which is the body of EU legislation and law, by requiring its trade partners to reform their policies and regulation in line with the European open market principles. So basically, it's promoting an EU model founded on EU values, and this is evident in its agreements that it signs with countries, and approximation clauses where the said country undertakes to gravitate towards these EU values to align its internal market legislation with that of the EU. So normal value-based approach, which the EU undertakes in its however, with Russia is it's not a entity that wants or line with EU norms and values, because it is a strategic partner. It's a force to be reckoned with. It's the use its usual carrots and stick approach with Russia, because the EU, much as Russia needs the EU is heavily dependent on Russia for its energy security as the largest gas supplier. So the usual approach in coaxing them in their policies in line with an EU model and EU values and EU norms, this will not work with an entity like Russia, where
at the end of the day, Russia is a strategic energy partner in which the EU is heavily dependent on its energy resources. So in that respect, we can see the EU engaging in more strategic, its interests lie its supply and its energy security. It does resort to other measures which it wouldn't ordinarily have to use with entities that are to gravitate towards an EU model and EU norms and values. I hope that.
Yes, thank you very much, Natasha. Please, as I said, in the audience, feel free to request the stage, and we may have time for that later, and feel free to put your questions in the chat. There are some questions there that we may be able to come back to at the end of the session. So just before we get to that, I was going to ask our next speaker, Dr. Namgoong, to give us his presentation. We also thankfully have Gérardy, who will be our final speaker today. And so Dr. Namgoong is an Associate Research Fellow at the Korea Labour Institute, the independent national think tank in South Korea specialising in labour studies. He researches in international labour law and international economic laws, and he advises the government on international trade agreements. He has a PhD in law from University College London, an LLM from Vanderbilt University, and an LLB from Korea University. And his articles have been published in various journals, including the International Journal of Comparative Labour Law and Industrial Relations. His presentation is called Stirred Not Shaken: The Meaning of Trade Labour Link Requirements Under Labour Provisions in FTAs. Thank you, June.
Thank you, Tania. I'd like to try to share with you my PPT slides. Can I do that?
Yes, thank you.
Okay. Can you see the my PPT slides?
Yes.
I hope it's not too small. Okay,
no, that's good.
It is small, right? Okay. Well, hello everyone again. My name is Namgoong, as introduced by Tania. And today I'd like to speak about the recent trade labor linkages, particularly in the form of labor provisions in FTAs. More specifically, I will focus on one question. What should be the meaning, role, and scope of trade labor link requirements introduced in such labor provisions in FTAs? Typically, the text of such requirements are like this: in a manner affecting trade between the parties, or these days, trade or investment between the parties. But there are many variants. So far, when it comes to labor provisions in FTAs, we have two cases where implementation of labor provisions was disputed by FTA parties. One was between the United States and Guatemala under the Dominican Republic Central America FTA, which was settled in June 2017. And the second one was between the European Union and South Korea, which was settled just recently. It was January 25th, I think, this year. In those two cases, there were many issues disputed and addressed, but in this very short presentation, I will only focus on how the issue of trade labor link requirements was handled by each panel. Here is the text of articles in focus in two disputes. I'd like to start with the U.S.-Guatemala case. I think at the top, you can see the text of the relevant article. So a party shall not fail to effectively enforce its labor laws through a sustained or recurring course of action or inaction. This is important. In a manner affecting trade between the parties after the date of entry into force of this agreement. that article was the main article disputed between the United States and Guatemala. The issue was whether Guatemala breached the article I just showed you, Article 16.2.1a. Among many issues, the key legal battle took place about whether Guatemala failed to effectively enforce its labor law in a manner affecting trade between the parties. The disputing parties never agreed on the meaning of that clause. Here is a snapshot about the arguments. I hope you can understand what this table means, because my reviewer told me this is very, very difficult to understand. Anyway, to the US, United States, a failure is in a manner affecting trade between the parties if that failure modifies conditions of competition. The US contended that the term affecting had been construed very broadly under WTO law, whether got or gets, in order to include measures that might adversely affect the conditions of competition between domestic and imported products on the internal market for the purpose of GATT Article 3.4, and any measures bearing upon conditions of competition in the supply of a service for the purpose of the GATTs. The United States found it to be analogous to the purpose of FTAs in this case. So the FTAs Article 1.2 provides as one of its objectives to promote conditions of fair competition in the free trade area. Well, in contrast, Guatemala refuted the United States claim by alleging that there must be a relationship between a course of action or inaction and a trade effect. And Guatemala argued that Article 16.2.1a, this one, requires an ambiguous proof that the challenged conduct has an effect on trade between the parties. Guatemala argued further that an assessment of compliance with GATT Article 3.4 requires a comparison between treatment accorded to an imported product and treatment accorded to like a domestic product. That modifications to conditions of competition are relevant only to this comparison. And that, finally, that since no such comparative exercise required by FTAs Article 16.2.1a, an assessment of the impact of conduct on conditions of competition is simply not pertinent. In addition, Guatemala contended that the Article 16.2.1a actually requires intent on the part of a party complained against. As for the issue of how to prove the affecting trade clause, so the issue of standard of proof, the two disputing parties, United States and Guatemala, disagreed as well. The United States alleged that a complaining party must present evidence demonstrating, first, that there is a trade between the parties, and second, that based on the responding party's failure in effectively enforcing its labor laws, there has been a modification to conditions of competition. The United States further pointed out that it does not matter whether such a failure has resulted in observable trade effects, and demonstrating it is not reasonable or feasible in this context. It is because basically all evidence is in Guatemala firm's hands. When it comes to the meaning of in a manner affecting trade, the panel first rejected Guatemala's narrow view that the relevant type of trade impact is limited only to lower prices or increased import or export of products or services. What matters here is not the end result in trade, such as changes in product price or market share. The panel saw there are more ways affecting trade other than just the price change or market share change by failing labor law enforcement. The panel highlighted that the wording here is affecting trade, not affecting the price or volume of traded goods. So by saying this, the panel rejected the Guatemala's argument. The panel did not agree with the United States either, but the panel began its analysis agreeing with the general proposition of the United States that a failure affects trade when it modifies the condition of competition. However, the panel found the difference in contextual settings between two different legal contexts. Specifically, it argued that unlike got and gets, where the term affecting merely defines the type of measure that is to be governed, thereby functioning as a threshold condition, the affecting trade clause in CAFTA-DR plays a more substantive role, forming an essential part of the obligation itself. Under this understanding, the panel found the notion of affecting trade to be more specific than merely trade-related. So, trade impact is not automatically presumed to take place as a result of any labor law enforcement failure, merely because of the fact that the employer concerned is engaged in competition with employers in the territory of the complaining party. Rather, actual evidence that demonstrates specific effects upon competitive advantage is required. So you can see in this table what the panel requires in order to satisfy the requirement in a manner affecting trade between the parties. Well, I have only 1 minute or less, I think. So I just quickly speak about what happened in the EU-Korea case. What the panel of experts in EU-Korea case was that you don't need to prove any kind of trade labor link requirement as long as we are talking about the articles in dispute between the European Union and South Korea, which I have an issue. The issue is one sentence. Under any text, as long as we are talking about labor provisions in FTAs, we are talking about labor issues in free trade context. There must be some kind of link between trade and labor, no matter how loose that is. So I slightly have an issue with the panel of experts, the reasoning in EU-Korea's case. Well, I'd like to have some more chance in later in our discussion time. Okay, thank you.
Thank you very much, June. I might ask Anna, she has a question for you, please, about your presentation.
Thank you, Dr. June. I really enjoy reading your paper. I think it's highly related with my research.
Yep.
And I also have the blessing to have in my as part of my members of my thesis committee, Professor Kevin Banks, who was president of the U.S. Guatemala. So I'm very familiar with this case. I definitely agree with you on your argument that there should be a linkage between trade and labor for them to be adjudicated in a panel. I just completely agree with your last sentence. However, I found in your paper that you pay a lot of attention on the role that economic incentives play in free trade agreements. And I will specifically talk about sanctions. What do you think about, or what would you respond to those scholars and people who think that using sanctions in a way to relate trade and labor is not the best solution?
Well, my very short answer to your question is you're right. And I don't think the sanction or economic incentives are the best way to address these labor issues, particularly in developing countries, because addressing labor rights abuse or labor rights violation is much more complicated than we think. So it's not just a matter of economics. It's more, it's deeply engaged in social, cultural context of that particular country or society. So when I talk about it is necessary to introduce some the economic incentive, or we need to impose some sanction, whenever I talk about it, I mean it as a last resort. We have to do first all kinds of dialogue, cooperation mechanisms, and then some, what is that, the supporting program, that comes first. But sometimes, perhaps mainly because the lack of insufficient political will of the ruling the class or party or the people in that particular country, then actually we have to move on to the next stage. I mean, some sanction mechanism. But before that, of course, we need to approach this issue with more the cooperation-based or dialogue-based the efforts. So I think you already mentioned the Professor Kevin Banks, and I also would like to mention the Kevin Corbin professor. I forgot where he is working, but they have produced a lot of great works, basically arguing that what you just talked about. So my short answer again, I agree with you. So yeah, that's my answer basically.
Thank you, June. So we might move on now, and we'll have time for further questions on that paper and the other papers at the end. So I'd like to now introduce our final speaker, who is Marie Gérardy. She is a PhD researcher in European law at the University of Luxembourg under the supervision of Professor Dr. Joanna Mendez. And after completing a double bachelor degree in European and Dutch law at Maastricht University, she obtained her master's degree in international law at Maastricht University and her LLM in European competition law and economics at the Brussels School of Competition. Marie has previously been a trainee at the European Parliament and at the European Standardisation Organisations, as well as a university lecturer in European Administrative Law at the University of Maastricht. And her presentation is on the embedding of private international standards into the EU legal order via international trade agreements. Thank you, Marie.
Good morning, everyone. I'm very sorry for all the technical issue. I'm on my phone now, so I hope everybody can hear me well. Thank you very much, Professor Voon and my co-panelists for such a great and smooth organization of the panel. I'm very grateful to be here and to be given the opportunity to discuss what is also part of my doctoral research. So today I would like to discuss about the phenomenon of private technical standards that are embedded into the EU legal order via free trade agreements. So first of all, what do I mean with technical standards? Well, if you look at the chair you're seated on, or the computer you're using, or even the glasses that you're wearing to look at this conference, every single object surrounding you in the room is subject to dozens of technical standards regarding its shape, its size, its safety, and its interoperability with other products. Now, originally, these technical standards are developed voluntarily, mostly by private actors on their own initiative, and they concern very technical, specific scientific issues. However, these standards are protected by copyright, and anyways, to make a long story short, there are various important economic interests involved in the process. This is, let's say, the private limb of technical standards. Now, these technical standards that are originally private voluntary instruments are often used by public actors, either because they are unable to regulate certain very technical globalized issues themselves, or because it allows a certain cross-border technical harmonization, which in turn diminishes technical barriers to trade. The EU, for instance, internally already heavily relies on a peculiar co-regulatory approach, whereby private technical standards detail certain legal requirements with a view to achieve the internal markets. These private standards are now, in fact, considered as being part of EU law, and there is a regulatory framework in place which imposes certain procedural requirements to European standard setters in order to gap certain legitimacy issues that might arise. However, what is sometimes overlooked, in my opinion, is that there are various other linkage points through which international technical standards may enter the EU legal order and acquire the ability to shape and influence public technical regulation. For instance, many European standards are in fact based, and by based I mean copy-paste, on ISO and IEC standards, which do not fall within the regulatory framework imposed by the EU. Second of all, various free trade deals incorporate technical standards, and the starting point for such embedding or linkage mechanism are the SPS and TBT agreements of the WTO. So under these two agreements, states undertake to not use technical regulation as a trade barrier, and this is verified by the fact that all of their technical regulation should be based on relevant international standards unless it will be proven ineffective. So some of these terms in this obligation are quite vague and have sparked quite a lot of discussion in front of the appellate body, but for the sake of time, I won't go in detail. But what is clear, however, is that this obligation is phrased quite firmly. So all of the 164 WTO members, whenever they want to issue a technical regulation, shall use relevant international standards. So here we have a certain degree of flexibility because we don't know which standards specifically, we just know that they have to be relevant, and also a certain margin of appreciation is allowed regarding the way these technical standards are used, because all that we know is that they have to be used as basis for technical regulation. Now, if a state does use technical standard as basis for its public product regulation, it will be presumed to comply with WTO law and therefore avoid disputes and sanction. This obligation has in fact been taken over and further enhanced in free trade agreements entered into by the EU. And for the sake of this paper, I have analyzed the CETA, so the trade agreement between UK and Canada, and the TCA, negotiated between the EU and the UK, to try to find out and map how and where technical standards are embedded and will influence EU law, and to what extent they will curb its regulatory autonomy. So I once again have to skip the details for time, but basically the reliance on technical standards as a means of regulatory cooperation is very present in these treaties. And next to the general obligation to base states' public regulation on existing technical standards, both agreements also contain quite a few provisions which incorporate technical standards by means of a direct de jure reference. So this is, for instance, the case of financial standards, aviation security standards, motor vehicle, certain medicinal products, and wine products. So in these product sectors, terms like technical regulation of each party should be in line with, or should be in conformity with, or should mutually recognize this and these technical standards. So through all of these categories that I have identified in my paper, it seems that international technical standards that can be private and which are developed outside the EU legal framework have the possibility to penetrate the EU legal order and influence its laws and legislation in a way that may not always be foreseeable. Now, why do I say not always foreseeable? Well, because the legal nature of these technical standards and the way they should be regulated remains quite unclear. Because originally and initially, as I said in my presentation, private international standards often have a mere recommendatory nature deprived from any de jure binding effect. However, the embedding of these standards in trade agreements, in fact, produces powerful harmonizing regulatory effect among WTO members, and one could argue, therefore, certain legal effect. So are they not part of the law, or are they a source thereof? And I believe that this question is very important for several regulatory reasons. First of all, the question of judicial review arises, which is paramount to any democratic society based on the rule of law. So are ISO standards, for instance, that are embedded in EU law, reviewable acts in front of the CJEU? It of course depends on the way they will be referenced in legislation, but what if a piece of legislation references an ISO standards without putting its text in the legislation directly? Will the CJEU be able to review this act? Second of all, the question of the application of antitrust arises, because in theory, in the EU at least, antitrust only applies to undertaking, exercising an economic activity, and this is the case for private standard setters because standards are protected by copyrights. However, competition law in theory does not apply to private undertaking exercising a public task. And if the standards they produce are used to operationalize the law, then one can wonder whether this could potentially be considered as a public task and therefore be exempted from competition law, Or then should we have competition law applicable to the initial stage of the process, but then once the standards is embedded into the law, then it should be exempt from competition law. Third of all, a problem arises when it concerns access to these standards. In any democratic system, whatever constitutes the law should be freely accessible to any affected parties. However, as I said, technical standards are protected by intellectual property rights, and it's very likely that if they would be stripped of such rights, so would the economic incentive to develop them. Consequently, should technical standards, at least the ones that are embedded into law, should they be freely accessible? And if so, how do states intend to grant this access without hindering the initial rights to freedom of business that standard setters enjoy? Fourth of all, and finally, when it comes to private or hybrid actors being involved in the making of national public regulation, the issue of legitimacy and accountability arise. In transnational settings, it is very difficult to envisage a regulatory system which would regulate the process, since there is no central authority to administer and legitimize such a process. And again, I repeat myself, but originally, most of these standards are developed by private instrument on a voluntary basis. And although they might benefit from it eventually, they might not know that these standards will be embedded and influence the law. So therefore, my $1 million question today is ultimately who bears the democratic responsibility of these standards, and how should we regulate standard setting processes without rendering them inefficient? So I realize I raised more questions than I answered, but thank you for your attention, and I'm very much looking for your questions.
Thank you very much, Marie. I'd like to start by just asking Anna to ask her question of you about your paper. Thank you, Anna.
Hello, Marie. I really enjoyed your presentation. It was very insightful, and I'm just gonna reflect on your last questions, which are very important for the evolution of international economic law. So I just have a very specific question here. Just let me here. So how should the standard setting process transform to create a better coherence between societal public interest and private economic interest, in your opinion?
Thank you very much. Well, this is indeed a great question, and this is what I'm trying to find out in my PhD. So maybe in a year I will be able to give you a full answer. But I believe it's a very difficult balance, because there has been some initiative, for instance, in global administrative law, to impose procedural requirements, because as I try to explain, these standards, and exactly as you said as well, these standards have societal relevance. However, we need these technical standards because governments' traditional decision-making might not be able to regulate every technical issue, so we need them. And if I believe, at least it's my personal opinion, that if we impose too many procedural requirements, then we might decrease the incentive to certain standard setters to set standards, and we also take the risk that they would not set standards anymore in official standard setting organizations such as the ISO, and they would just go to private consortia to not be bothered by all these procedural requirements. So that's why I believe that the answer lies more in economic law, such as antitrust, because the funny thing is that, at least in European law, the way technical standardization is regulated, there's a guidelines of the European Commission to give more guidelines on where technical standards could pose a problem to competition law or not. And the funny aspect is that in these guidelines, a lot of procedural requirements are used, and the same one that we may see in global administrative law, such as transparency, participation, and free access on a friend term. So I believe that my research and my answer would go more towards the thorough imposition of economic law, such as competition law, and in the EU also internal market rules. I think it would be the best equipped to deal with that.
Thank you, Marie. I also wanted to ask you whether you could say a few more words about the kinds of strategic or opportunistic behaviours that might be seen in the private decision-making process.
Thank you very much. Well, in standardization, we have a potential problem which is called hold up, because in certain technical standards, especially in the telecommunication sectors, they are very technical and they're protected by copyrights, but also certain patents are included in these standards, and these patents are owned by private companies. And once a standard is used, then the whole, usually because there is network effect produced, and a whole sector will start using the same specific technical standards, because the goal of standardization is to have the same technical solution to the same problem. So once a standard is used, then it means that other standards become less relevant. And if there's a technology, a patented technology in these standards, then companies might start asserting their copyrights in a bit of an opportunistic behavior and start setting a very high price for their patents. Also, I believe that this is more on a logical level. If there are several companies that are using different standards, we've seen what we sometimes refer to as standard wars, because if the standard is harmonized at the international level, companies will compete very heavily to have their technical solution recognized instead of perhaps the most scientifically sound solution, because of the cost of adjusting to someone else's technology. So we've seen that at the international level with the MP3 standards, the MPEG, and so onwards.
Thank you, Marie. So I might turn to one of the questions in the chat, which is a question to Anna. And this question is from Abu Saleh, who asks Anna, how you view the suspension of preferential treatment in favour of least developed countries in order to promote labour standards, and in particular whether you see that kind of suspension as being legal or legitimate.
Thank you, Professor Tania, and thank you, Lothar. Is it no? Abu Saleh. This is such a hard question, and I believe I will need. I cannot give an answer for a very broad question. It will be to be very, very specific. Yet I believe that that preferential trade agreements or preferential trade are tools in order to build a fairer trade agreement, or a better standards for fairer rights between countries. So originally, at the very beginning of the multilateral trade system in the late 40s, it has some exemptions and it has some preferential areas in order to achieve in order to level the field between countries. So originally, as the countries will be achieving a better economic growth, they will be to some extent graduating from these preferential treatments and from these exemptions. I'm not very sure on which specific case Abu Salem is talking about, and I think it's a very interesting question. So I think we should, I just would like to have more information in order to give a very specific answer.
Can I ask you another question, Anna, which is from the chat? It's from Desiree Leclerc, and she's asking if you're aware of scholars who are writing against sanctions in trade and labour, because it seems that more recently advocates tend to be taking the opposite stance, suggesting that labour provisions have to be binding and backed by sanctions. And so whether you're aware of anyone arguing to the contrary.
Yes, thank you, Professor Tania. And I was actually at this moment, I was typing to Dr. Leclerc. I'm such a huge fan of her work. I follow the blog where she was commenting on the EU Korea case, and I was so pleased of reading her to write to me. So I was about to just answer to your question. I do believe, as you mentioned, that the scholarship is moving towards the believing of sanctions, that sanctions are necessary. And I to some extent, I think that this is something that binding agreements is something that is missing in the human rights area. However, I think what I was mentioning is, as Dr. Jun said, it is not only about sanction. It should be something before we should be talking about more cooperation and more other ways in order to before just moving into the sanctions area. And also history shows that there has been some reticence from developing countries in order to accept the idea of linking trade and labor rights because of the effects that sanctions may have in their economy, and rather than be more beneficial for them, might be hurting the economic progress of those countries which will be receive the sanctions. I will look further in order to reply to your specific question before just mentioning professor by themselves. I think it will be a little bit awkward to give names right now, but thank you, Professor Dr. Leclerc, for your question.
Thank you, Anna. June, I might ask you whether you have a response to a question in the chat from Josephine Adeyele about what legal criteria exist or have been considered so far for identifying what constitutes development, financial and trade needs, given the requirement that labour or non-economic conditions in trade agreements with developing countries, so for example, under generalised systems of preferences, should address those development, financial and trade needs?
I think, first of all, I'd like to highlight some difference between labor rights or labor standards and the other social values we are talking about in this context. I think labor rights or labor standards have been more controversial and controversial because labor standards have clear, in some context, clear economic implication, and because of that nature, that issue has been more sensitive than others, I think. And so, what the cases I analyzed in this presentation and in my paper published back then was in the context of FTAs, and then especially in the case of U.S. Guatemala, and the panel and as well as the United States approached that issue from the lens of fair competition. So it was more economic matters to them. So, but as far as I understand, Professor Adeyele asked here is, I believe this approach it comes from more development perspective rather than some fair competition and particular trade. So I think so they have some difference in nature. One in U.S. Guatemala, for example, approached that issue from more fair competition perspective, but here in GSP context, this is more development issue. So was the case in EU Korea. So where the panel of experts consider the importance of a trade labor requirement very minimal. I think that is the reason why there have been differences between the FTA cases and the fair competition logic and this development logic we can see in GSP and the enabling clause in WTO context. I'm not sure I answer the Professor Adeyele's question properly, but that is what I can think at the moment. And yeah, and if that's, I might take some more time to digest the question and prepare for my answer. And then there's another question for me to answer.
Yeah, would you like to answer that question from Abu Saleh? Is there any positive evidence to support effectiveness of trade labor sanctions?
We only have, so far, we have only 2 cases. So it's, to be honest, it's hard to say whether it is effective or not. And I am aware that there have been much literature on this particular issue so far, basically saying we need more effective mechanism. For example, by introducing the trade sanction or economic sanctions in the case of EU FTAs, which now do not have sanction mechanism. And I understand that, and I think that is a reasonable the argument that can be made. But as I asked Anna, it would be more effective when they are used as a last resort, when every other attempts is the sought, and then finally still, but it is still it doesn't address the issue, then the sanction mechanism comes into play, I think. So short answer is we don't have enough evidence to say whether it is enough the effective or not. But I'm Korean, and as a person who sees the case EU Korea in the front line, well, it's not as effective as we want to see. I think it is moderate, because we now have ratified the 3 ILO fundamental conventions, which was one of the issues between the European Union and South Korea. So I think it is too early to say it's not effective, but still it is worth thinking about what we can do more and better for this. I think so.
Can I also ask you to ask? Do you have a question about Marie's paper?
Mm-hmm. Yes. Well, Marie's paper. So, okay. Thank you, Mary, for your presentation. And I read your paper. I really enjoyed reading your paper, and your paper was full of thorough legal analysis, and it was very informative. And for that, I really appreciate. So it was very hard, to be honest, very hard to find anything I disagreed with you. And then because of this, it's again difficult to ask a question. But it was my impression that in your concluding remarks of your paper, while you acknowledge the legal dangers and some normative issues brought therefrom, you understand and consider as almost inevitable the current trend of embedding private technical standards in public law. So I'd like to ask you, is it my understanding correct, first of all? And if that is correct, then I'd like to ask, do you have in your mind some idea of solution, whether it is a big step or a small step? Also, among the categories, according to your typology of embedding mechanisms in your paper section 2.4, do you have any preference, or put differently, which category would you consider to be better or more desirable than the others, based on your own normative criteria, which I believe is not present in your paper or presentation? So that is my question.
Thank you very much, June, for these 2 very interesting questions. I'll do my best to answer them, but let me know if it's not quite the answer that you were looking for. So regarding the first question, if I understand correctly, you are wondering whether it's inevitable that public governments are using these private technical standards. And I believe that at this day and age, with the increased globalization and the technology that is growing everywhere and is definitely growing much faster than any traditional decision making can cope with, I really believe that we need private actors. We need experts to help regulation and to help government. And that going to a completely private self-regulation of this issue is not a good thing on its own either. So I really think that such a co-regulatory approach is actually very desirable and inevitable. However, the way it's put it in practice, as I try to show in my paper, is a little bit tricky. But I think we should strive to find a way that to make it work. So that's my answer to the first question. I don't know if it's what you were looking for. And regarding your second question, so if because as you read in my paper, I made different categories of the way technical standards are embedded into the CETA and the TCA. I didn't go into quite a lot of details during the oral presentation, but I do not think there is one that is more ideal than another. I just think that what I call the de jure reference, so where the text itself mentions that this and this specific standard from this and this standard setting organization should be used, then when it comes to a democratic legitimacy perspective, I think it's better than the de facto reference where we only knew that relevant standards have to be used, because there one can argue states themselves decided to, when they signed the agreement or the treaty, to recognize these standards as achieving a high enough regulatory goal. However, when it comes to the de facto reference, so when they have to use relevant standards as basis for their regulation, not really knowing which standards are now relevant, nor which standard will be relevant in the future, there I think that more issues can arise. There's less foreseeability.
Right. So not easy.
Not either.
Not easy at all. Thank you.
Thank you, Marie. Now we need to finish, but I just wanted to ask before we go, Anna, whether you would like to respond to Lothar Ehring has a couple of questions in there. I haven't been able to get him to come and ask them in person, but so his questions are about the relationship between international trade and human rights, and also how human rights is dealt with in terms of the different human rights and the relationship between human rights and exceptions in trade agreements. Do you have any reflections on the comments that he's made?
Thank you, Professor Tania. I am actually reading the questions and public chat. I think the concern here is that I think he mentions that we are talking about different kind of laws, whereas human right is more about domestic law and international trade, about the law of the nations. I think after the Second World War, there was an understanding that human rights or the protection of human rights is also a concern of international law. So, and of course, there is states has the sovereignty rights of regulated, but I think that I think it's important to find a balance between these two areas. And I think we should be very, very careful when we talk about the relationship between human rights and trade. And I will also would like to link this comment with one of that we have from Christian Haverly, that she talks about how the WTO cannot address social dumping. And I think although I do believe that we should take into account that there is an estrangement, an institutional estrangement between trade and human rights, we also need to pay attention on the role that human rights, the human rights regime should be taking in order to achieve this better integration. We cannot just say that it's all about trade, and also we should take into consideration that at this point maybe some countries that don't consider social and economic rights as part of human rights, or maybe, although I think it's a overwhelming agreement that labor rights are human rights, there may be some parts of some countries that don't think this is the specific issue. So I think when we talk about how the WTO cannot address social dumping, it is also the way that individual states address human rights concerns, and we should remember that it's not the WTO is an organization that is is driven by the states. So as far as the states or the state members wants to do something, the WTO will be able to do it. So it's also, we need to remember the importance of the role that states plays in the attainment of securing human rights.
Thank you very much, Anna. So we need to end there. I'd like to thank all of our speakers, also Natasha, who's unfortunately seemed to have dropped off. And thank you to everyone for joining the panel and for your questions. They're really helpful to the panelists, I believe, and we really appreciate your engagement. So thank you and enjoy the conference. Bye-bye.
Thank you.
Very much. Bye.